application for permission to appeal in the matter of the claim on the application of Ammori and the Secretary.
Yes, Mr Hussain.
My lady, my lords, thank you very much. May I make 5 very short points before I address the grounds of appeal? I know the time. 1, my lady, my lords will be aware of the tradition of civil disobedience in our country. As Lord Hoffman said in Jones, for the references, page 647 of the authorities, civil disobedience on conscientious grounds has a long and honourable history in this country. People who break the law to affirm their belief in the injustice of a law or government action are sometimes vindicated by history. The suffragettes are an example which comes immediately to mind. It's the mark of a civilised community that it can accommodate protests and demonstrations of this kind. Second point, my lady, your lordships be aware, this is the first time in our history that a direct action civil disobedience group which doesn't advocate for violence has been sought to be prescribed as terrorist. Third point, the special rapporteur, Professor Ben Saul, was strongly supportive of our submissions. See the judge below, paragraphs 21 to 22. Fourth point, my client, Ms Ammori, the co-founder of Palestine Action, has explained that she was inspired by the long tradition of direct action in this country, from suffragettes to anti-apartheid activists to Iraq war activists, people taking action to prevent harm before it happens through lock-ons, sit-ins, blockades, and damage to property. That's paragraph 30 of her statement, page 187. Fifth point, one of her witnesses, Mr Feinstein, an award-winning expert on the arms trade, a former ANC member of Parliament in South Africa under Nelson Mandela, someone, as he says, actively involved in the liberation struggle against apartheid in South Africa and the child of a Holocaust survivor, evidenced that claim at paragraph 11 of his statement, page 444. Those are my 5 short points. The grounds of appeal, you'll see, my lady, we have 5 grounds. Miss Nigrali, with your leave, will address you in ground 4. I have carriage of the rest. Ground 1, we say the judge erred, and here please look at paragraph 98 of his judgment. We say the judge erred in law that it would be wrong to accord significant weight in the balance to the interests of those who deliberately flout the law. And essentially what he did is he just didn't posit the required counterfactual, because the hypothesis on which interim relief needs to be approached is that by assessing the balance of convenience on the basis that the claimant is successful, if the claimant was successful and the prescription order was found to be unlawful, the persons referred to in the judgment at paragraph 98, it will be then to decide what to do. Incur criminal liability, it will be on them, effectively he's saying. Those persons will have been arrested and detained pursuant to an unlawful order. The undisputed consequences of that are summarised in the witness statement referred to as judgment 18, and I've asked for a subsequent note to be sent to you. That's our skeleton at 96 to 106. Sorry, the reference wasn't there. And they include deprivation of liberty, loss of employment. Those harms are irremediable, even if the order is ultimately quashed. That's our first ground. He just didn't posit the correct counterfactual. That leads on to ground 2. By failing to do that, he just didn't accord weight in the balance of convenience to the interests of those deliberately flout the law. And that could be a statement, I support Palestine Action. 14 years prison sentence, detention in remand, quite possibly. Subsequently, the order is quashed, and there's been that deprivation of liberty. So that sort of statement is intrinsically protected by the law. Even direct action, it does not lose the protection of itself by Articles 10 and 11 Hallam. So the range of activities, some purely protected, some protected, see Hallam. And the authority, we give you reference to the authority. Ground 3, national security. We say at paragraph 95, the judge erred in accepting that there was a national security justification outweighing the prejudice to those adversely affected by the order in circumstances where the Home Secretary filed no evidence whatsoever addressing why the introduction of the order was urgent. So not even a sentence saying, I can't explain why it's urgent, it is urgent. Not even one sentence. In circumstances where there are extensive existing criminal law powers, civil powers as well, and the Home Secretary had waited for over 3 months to introduce the measure. And she was given an opportunity not just once to provide evidence on the Tuesday of this week, but also this morning. She provided none. And accordingly, on the approach in the authorities, although national security attracts deference by the court on both constitutional and institutional bases, nevertheless, the reasons need to be scrutinised, the reasons and evidence. There was none in our respectful submission. Ground 5, skipping over ground 4, we say the court erred in considering that the availability of an appeal to POAC would be a hurdle, a potential hurdle, not a bar, but a hurdle, which the claimant would in due course have to cross. The position, we say, was abundantly clear for the reasons we set out in our skeleton at paragraph 1, 2, 3. Judicial review clearly has not been ousted. Interesting debate about whether it ever could be. Nothing approaching it. Secretary said accepted that. Therefore, in a situation where the order wasn't to be brought into force, the statute didn't confer any suspensive remedy. The consequences were as grave as they are. The consequences touched values protected by our common law free speech, protection against arbitrary detention, protected by convention rights, Article 5, Article 10. It was obviously the case that judicial review was available, and the existence of a statutory remedy without suspensive effect against a decision not to deprescribe clearly was nothing like an adequate alternative remedy. Indeed, it was no alternative remedy at all. Those are my submissions.
Very efficient. Well done.
Thank you, my lady. Ms Grally will address you on ground 4.
Round 4. Thank you very much.
My lady, I may not be able to be quite so efficient, but I will attempt to be so. Ground 4 concerns the court's error in its approach to Articles 10 and 11. It is the appellant's case
Different to ground 2.
This is ground 4.
Is it different to ground 2?
Yes, it is different to ground 2. We say that the court failed to find that the defendant needed to have regard to the proportionality of the interference with Articles 10 and 11 in deciding whether to prescribe Palestine Action, because that decision in and of itself was capable of giving rise to a breach of a restriction on Article 10 and 11 rights, having regard to the chilling effects to which it was capable of giving rise. There was no evidence before him of any assessment.
Sorry, I can't hear you. My fault. Could you just speak up, please? Having regard to the chilling effect.
Having a regard to the chilling effect to which it gave rise.
Thank you.
There was no evidence before him of any detailed assessment of the impact of rights to which that decision would give rise.
No evidence of?
Detailed assessment.
Of what, though?
Of the impact on Articles 10 and 11.
Oh, impact on 10 and 11, not.
To which the decision to prescribe.
So just to help me, is this to do with his assessment of the merits, or is it's his approach to the balance of convenience?
It's his approach to when he considered Article 10 and 11 were capable of being engaged and capable of being unlawfully restricted.
So to repeat my question.
So it's both.
He obviously found that there were, whatever the phrase is, he found that the Article 1011 claims gave rise to a serious issue. So the first question.
Indeed.
Are you unhappy with or attacking or criticising his approach on that question?
So we attack his approach on that basis in the sense that, notwithstanding that he considered that there was a serious issue, he failed then properly to undertake the balance of convenience exercise.
So it's a balance of convenience argument, is it?
It includes a balance of convenience argument.
Right. Okay. Thank you.
And the balance of convenience argument in particular is that instead of assessing the balance of convenience on the evidence before him, he considered that there would be further evidence that the Secretary of State could rely on them in the future, and considered that in his assessment, rather than assessing the balance of convenience on the basis of the evidence before him. So that's the balance of convenience argument. But the submission that I was making is that the court failed to have regard to the fact that the very fact of...
Just sorry to interrupt you. Just give me the paragraph reference where he deferred it or referred to future evidence.
I think it's 72.
72.
Just at 70, it's in the 70s. Let me 73. So the court says
It's difficult to evaluate. So this is in the merits section, yes?
yes.
What's wrong with this? I mean, he has to... We know there's an application for a declaration under Section 6 and there's Section 8 permission application. So what did he do wrong?
So what he did wrong was he was required to assess the balance of convenience on the evidence before him. And the balance of convenience on the evidence before him, in our respectful submission, fell in favour of the claimant, having regard to all of the evidence, including the chilling effect on free speech, the fact that people would be criminalised and criminalised as terrorists for engaging in protest that was not violent, for the simple fact that they were associated with Palestine Action. He had evidence before him of the evidence on possible employment rights, on education rights, on the right to liberty. And he failed properly to determine that the balance of convenience fell in the claimant's failure on the basis that there was evidence in the future on which the defendant could rely that might, in effect, tip the
Where
balance.
did he do that in the balance of convenience section? So he says difficult to evaluate ground 2 at this stage because there may well be more evidence. So where in the balance of convenience exercise does he make this error, did he say?
Well, we say the very fact of suggesting that he couldn't, that there was future evidence on which he could rely that would tip the balance of convenience.
Show me
was
where
an
that
error.
is, please. Show me where he says that.
Well, that derives, we would submit from paragraph 73
He's
itself.
not in that section. He's dealing with the merits, whether there's a serious issue to be tried on ground 2. I may be wrong. I think I'm right, isn't he?
Yeah.
So he's looking at, is there a serious question to be tried on ground 2? And he says, I just, well, he says it does raise a serious question.
He says there is a serious question to be
Yes.
tried, but he just cannot evaluate the strength of the ground of challenge at that time, because it's likely to depend on evidence.
Right. So it's a complaint about his he didn't say that ground 2 was as strong as it actually is on the evidence that he had. But just help me with how that feeds into the balance of convenience exercise. Where in the balance of convenience exercise does he say, I'm going to speculate there may be further evidence one way or the other that influences me here?
It's because the balance of convenience, in effect, to a certain extent, turns on the merits, and this is set out.
No, he didn't turn on the merits. He took it into account. Okay,
He had
so
borne in
bearing
mind-
in mind his assessment. So you say wrong to even take into account the fact there might be further evidence. As a result, didn't put the prospects of success on ground 2 as high as he should have done. As a result, the balance of convenience exercise is flawed because the merits played a part in it.
Indeed.
Right, okay. Thank you.
The court also, in relation to Articles 10 and 11, failed properly to consider that the prescription order would cause irreparable harm to the Article 10 and 11 rights of a significant number of affected individuals, including on the basis that they were insufficiently clear. And that is the fact, even if they were to remain in effect only for a short period of time. There was significant evidence before him to demonstrate the chilling effect of the order, because it was insufficiently clear, because people would self-censor entirely. They would not, for example, attend protests against Israeli arms factories previously organised by Palestine Action to avoid falling under the proscription regime applicable to Palestine Action. This is relevant in particular to protests outside Elbit factories. It would also apply to slogans previously used by Palestine Action, such as "Shut Elbit Down," advocating for the closure of Israeli arms factories would be capable of being associated with Palestine Action and therefore capable of attracting the prescription consequences that would flow from that. There was also, he also failed to take into account the sufficient evidence before him that the order was capable of criminalising and would criminalise as terrorism a vast number of individuals who would wish to continue protests, so whose speech would not be completely curtailed, but would fall foul of the prescription regimes due to its lack of clarity. And the way it, so for example, people who would use red paint, for example, against arms factories, or wear red boiler suits that have previously been associated with Palestine Action, would potentially fall foul of Section 13, for example, despite no longer associating with Palestine Action itself. And he failed to consider that the prescription regime was not necessary in a democratic society because it wasn't proportionate to the aims sought, because there was alternative methods available to prevent the serious damage to property that was an issue. And those are dealt with at paragraph 46 of the submissions. They include injunctions, they include other forms of restraining order, of which there was no evidence that there had been any attempt to obtain them in the case. The court also improperly held that Article 10 rights of all persons capable of being associated with Palestine Action were of reduced weight in light of the acts of serious property damage caused by others. That was an error of law. The case law, including the ECHR case law, makes clear that Article 10 and 11 protections are not lost on the basis that protest actions may amount to criminal conduct. Damage to property is not always to be considered violent. That is clear in the Hallam case, even where they are said to amount to thousands of pounds of damage. And importantly, what the case law is particularly clear on is that a person doesn't lose the protection of Article 11 simply because violent action by others in their organisation, because others in their organisation have committed violent acts. And the authority for that is Primov in Russia. Primov and Russia.
Yep, and that's in the bundle, is it?
That's quoted in Ziegler at paragraph 69, and that's it.
Ziegler's in the bundle, is it?
It is, AB 411352. And in that, the court recalled that Article 11 doesn't cover demonstrations where the organisers and participants have violent intentions, but an individual does not cease to enjoy the right to peaceful assembly as a result of sporadic violence or other punishable acts committed by others in the course of the demonstration, if the individual in question remains peaceful in his or her own intentions or behaviour. So the fact that some actions of Palestine Action protesters have been considered violent by the Secretary of State should not and could not remove Article 10 and 11 protections or weaken Article 10 and 11 protections in relation to individuals involved in the same protest who did not themselves have violent intentions, much less individuals involved in other protests, perhaps across the country, who also didn't have violent intentions. And what's particularly relevant to that, my lady, is the evidence of Andrew Feinstein, which is at tab C11, page 444 to 445, and he presents an overview of the actions of Palestine Action that is worth considering. He says that, I quote, "I follow Palestine Action closely on social media and would estimate that it has engaged in approximately 500 actions. These include demonstrations, banners and red paint at strategic locations, blockades, lock-ons, protests, blocking of gates, occupation, climbing onto roofs, use of hammers to damage fences and buildings and their contents and similar. All of those actions are now not only criminalised, but criminalised as terrorism, even though they would otherwise attract the protections or fall within the ambit of Articles 10 and 11. He says at paragraph 13, "The aims of Palestine Action have never been to target people. Instead, they have acted against infrastructure that has been proven by verifiable research to be complicit in the illegal activities against the Palestinian people. The vast majority of people I have encountered in Palestine Action identify as pacifists," and he provides a list of protests related to Palestine Action, which are all of the type of conduct which the European Court of Human Rights and indeed domestic courts have repeatedly found to engage Articles 10 and 11, and that's set out at paragraphs 30 to 35 of our submissions. As I say, those are all actions that will now be criminalised on the basis of that they are committed by individuals in a loose network of protesters associated with Palestine Action, along with some, which also comprises some people who are alleged to have committed large-scale criminal damage. The fact that an organisation is asserted by the Secretary of State to be engaged in terrorism on the basis that some actions have assertedly consisted of violence cannot remove Article 10 and 11 protections from all persons who are associated with that network, regardless of the nature of the protests that they're engaged in. There's no magic to the determination of terrorism. The court accepted at paragraph 100 that in determining the broad criminal prohibitions imposed by the Act as it would apply to Palestine Action could chill entirely lawful protest, could give rise to social stigma and other consequences, but determined that that was effectively lawful on the basis that this was the inherent consequence of a regime which aims to disrupt and disable organisations which meet the threshold for prescription which the Secretary of State and Parliament decide to prescribe. But what that failed entirely to engage with the fact that the regime applied to Palestine Action would curtail legitimate rights, because Palestine Action is not the type of organisation like Al-Qaeda or ISIS that is typically falls to be prescribed under the prescription regime. It's, as Andrew Feinstein's evidence set out, its primary objective and activities are not concerned with violence. And finally, the court failed to consider, and this was the authority to which I was taking my lady earlier, that the very fact of prescription is capable of giving rise to a breach of Articles 10 and 11. The very fact of a decision to prescribe, that is, even where it has not come into effect. And the facts of the case of the Christian Democratic People's Party of Moldova are particularly relevant in this regard. That concerned a 21-day ban on the activities of a political party. It was considered to be disproportionate to the chilling effect that it had, even though it never entered into force, and even though the ban was never enforced. And that was on the basis, inter alia, that there was no proper warning, so that people were not able to foresee the consequences of the order. The court considered that the timing of the ban was materially relevant, just like we assert that the timing of the ban here is particularly relevant, having regard to the desire of people to protest against the ever-escalating conditions in Gaza, which many in the international community consider to amount to genocide. The court failed to consider that even a short curtailment of rights up onto the determination of this claim is capable in and of itself of constituting a serious breach of Article 10. and therefore is unlawful pursuant to Section 6(1) of the Human Rights Act, which of course domesticates those rights into British law and makes it unlawful for a public authority to act in a way which is incompatible with convention. My lady, those are my submissions.
You've been very helpful. Thank you very much indeed. Anybody else on the claimant side? No, thank you very much indeed. Would you just give me a moment, Mr Watson? Yes, Mr Watson, we would like to hear you on grounds 1, 2 and 4. If there's anything that you think you really do need to say on grounds 3 and 5, then please do so. But otherwise, grounds 1, 2 and 4, please.
I'm grateful, lady. Of course, we invite this court to refuse permission. The court will be only too well aware of the high threshold the applicant has to surmount at this stage. PCSU, Rwanda, paragraph 84 in particular, looking for a threshold where the lower court's conclusions are irrational or otherwise plainly incorrect. In those circumstances, will the decision in this context be reversed? Grant of interim relief is discretionary. The exercise by a judge of discretion shall be afforded deference by the appellate court. We respectfully submit to, from that same case, paragraph 85, that an apt description of the judgment here is that the judge produced a detailed and careful judgment, all the more impressive in view of the time constraints under which he had to give it on a Friday afternoon. We respectfully submit all of that applies properly here. And to address grounds 1, 2 and 4, it's important, my lady, my lords, to set the framework for this because it affects all of the grounds and my response to each of them. The landscape here on appeal is one where the judge decided that there was no serious issue with respect to the claimant's grounds 1, 3, 4, 5, 6, 7, 8, and there is no appeal against any aspect of his lordship's decision on those grounds. That's important because those grounds in the lower court, 1 and 3 to 8, included and exhausted the challenges to the Secretary of State's conclusion that this organisation was concerned in terrorism, and also involved the judge's rejection, or at least finding that there was no serious issue raised, with respect to the exercise of the Secretary of State's discretion in deciding to impose, prescribe this organisation. That any appeal has to contend with an acceptance that those grounds were properly rejected, and therefore that there is no serious issue as to whether this organisation is concerned in terrorism or the Secretary of State's exercise of discretion. The only serious issue to be tried that the judge did identify, which of course I'm going to address, is Articles 10 and 11. But again, my lady and my lords, looking at the judge's analysis of the balance of convenience, so we get through serious issue to be tried on that ground alone, relating to Articles 10 and 11, then through to balance of convenience. The judge properly identified, we respectfully submit, and again there's no challenge to this, the starting point, which is that there are two very significant public interests in play that weigh heavily on one side of the scales before we turn to look at the impact on private rights. My lady, my lords, that is in paragraph 48 and 49 of the judgment. Having set out principles that are not in dispute and not in dispute on appeal, the test for interim relief in this context, obviously American cyanamide provides the basic framework, is paragraph 47. Then Lord Justice Singh and Mr Justice Chamberlain in FTDI Holdings consider that in the context of a national security case and an application for interim relief, and held here the context being one where the interim relief sought would suspend the effect of an order which the Secretary of State considers is required in the public interest and which has been affirmed by both Houses of Parliament, because that's, of course, the process that's left us with an order prescribing these organisations signed by the Home Secretary that will take effect at midnight tonight, subject to any intervention by the court. In those circumstances, paragraph 48, other things being equal, there is a strong reason to allow the Secretary of State to make the order in what she considers to be a lawful manner. And that, of course, the ordinary and broad public interest of letting the law of the land take effect. Lord Gough of Cheveley. No criticism or challenge to that. And then secondly, the important additional weight, the context here increases the weight to be accorded to public interest in allowing the Secretary of State to make the order. For institutional and constitutional reasons, the courts accord a wide margin of discretion to the executive when taking decisions about how to protect the public from risks associated with terrorism. So immediately, and accepting as we did and as the judge held, the court holds the scales when looking at the balance of convenience. There is no suggestion that the judge was wrong to start that process of balancing with two very heavy public interests on one side. It's against that background, my lady, my lords, that we then have to look at the criticisms that are now made of the particular exercise of the balancing of convenience, the balancing of interests, on the discrete points that have been raised, so grounds 1, 2 and 4 on appeal. Firstly, on ground 1, and the overarching point going to be against that context, this is of itself an extremely narrow criticism, given the whole structure and architecture of the lower court's decision. It's a criticism that goes, in fact, only to weight. We're in a balancing of interests territory. It's identifying one of the strands of issues that were raised before the lower court and suggesting that the whole of the judge's ultimate conclusion is wrong because of an error in the way he analysed this particular point. All of that, we respectfully submit, is extremely difficult territory, if not impossible territory, on an application to this court. But looking then at what the actual complaint is, the actual complaint under ground 1 is a peculiar one with respect, because it is the suggestion that in considering the balance of considering the private rights that would be affected, the learned judge failed to accord significant weight or sufficient weight to the rights of those who deliberately decide to defy the law. Now, the respectful submission I made before Mr Justice Chamberlain, it's very difficult to see how one can afford any weight to that right in circumstances where it's a deliberate flouting of the prescription legislation. It amounts ultimately, my respectful submission, to an interim challenge, because it is being said, if you make this order, we will all flout it. There will therefore be mass arrests, and therefore there will be mass interference with our private rights. My respectful submission, that cannot be prayed in aid in the balancing exercise. But the learned judge, in fact, was rather more generous than...
He gave it some weight.
He gave it some weight.
That's fine. I think we've got ground 1.
I'm so sorry.
Ground 1, yeah, okay. Ground 2.
My lady, I'm sorry, because I haven't been able to print off the indicative grounds, so can I just... Yes, Article 10 and 11. Well, my lady, my lords, this is a classic, we respectfully submit, weight challenge, because it's very clear from the judgment, C in particular, paragraphs 97 through to 101, that the judge conducted a very careful analysis of all of the matters that were relied upon that he accurately set out earlier in his judgment at paragraphs 52A to C. He was alive, and there was significant discussion and consideration before the lower court as to matters relating to chilling effect, to inadvertent commission of offences, the implications that this might have of casting a long shadow over legitimate speech, the implications it would have for curtailment of the expression of Article 10 rights, even in circumstances where it could be said that the action itself was unlawful, again, a difficult point to put in the balance in terms of asserting a private right. But even if you assert I have a private right to conduct unlawful activity, there is some extent to which it's protected by Article 10. All of those matters, my lady and my lords, are considered in that analysis through from paragraphs 97 to 101. And the judge was entitled to reach the conclusion that weighing those matters in the balance, ultimately it came down against.
But Mr Watson, there's a specific criticism. Do you say this specific criticism is made out or not? I understand you look at it all in the round, you look at it all together, the overall outcome. But there's a specific criticism. What do you say about the specific
Yes, and this is,
criticism?
and we're on ground 2.
We are.
And ground 2 is paragraph 98, wrong to accord significant weight in the balance to those who plan deliberately to flout the law.
Because, so different reason this time to ground 1, because they themselves attract the protection of Articles 10 and 11.
Yes, Ale, but with a greater respect, I don't see the differential analysis here between this and ground 1. It's the same point. There may be a residual argument that Article 10 protects your rights to some form of criminal activity, but in fact, paragraph 98 is not describing that. Paragraph 98 is referring to individuals who choose to continue to express their support for the organisation, it's having been prescribed. That's the setup.
Now, is ground 4 separate?
And then ground 4, I understand to be separate, yes, which is the general criticism on Article 10 and 11, and those are the court has my points on that. This is about the judge's assessment and evaluation of each of those matters, and it's an attempt, in my respectful submission, simply to relitigate the issues that were all carefully considered by the lower court and reflected in his judgment in those paragraphs, 97 through to 101.
The matters raised in ground 4 are addressed in paragraphs 97 to 101, are they?
Yes, my lady, that's... Sorry, my lady. I'm reminded. There's a slight conceptual difficulty with respect to ground 4 because, in fact, as was considered in the discussion earlier, if and to the extent this is referring back to the earlier decision about serious issue to be tried.
Well, there are 2 points. The one is that it led to an inadequate assessment of the strength of ground 2, which is said to feed into the overall outcome. That's point 1.
Yes.
And then the second aspect of it, without doing justice to the elegant oral submission, is irreparable harm.
Yes.
And what do you say about the criticism that on the ground 2 finding on the merits that the judge was wrong to take into account the possibility of further evidence down the line?
Well, my lady, in this context, in terms of the balance of convenience, he had...
in the context
I
of where he was saying, at this stage, I can't say much more about
Yes, but he...
there may be more evidence. Was that wrong in principle or an error of law?
No, my lady, because he's decided that there was a serious issue to be tried.
Yep.
And so we're through into the balancing exercise, which he then conducted. There's no suggestion that when he came to the balancing exercise, considering the material before him, thought, well, nevertheless, when I conduct that balance, I must remember that there may be more coming. He's only referring to the fact that at the moment, I can't say that I can't remember the language, it's a strong case. Perhaps.
Serious issue.
I'm so sorry. No, he finds it's a serious issue.
Yeah.
But then he goes on to say, but I can't say that there's a strong case.
Excuse me a moment.
Sorry.
I'm going to ask you to write the response to ground 4. So I'm asking. I will do the others. Forgive me. Thank you very much, Mr. Watson. Carry on.
The short point is, so 70 to 74 of the judgment is where he considers ground 2. The conclusion reached is serious question to be tried. At present, not possible to say this ground has a strong prospect of success, but that further observation is not held against the applicant later on when he comes to the balancing exercise.
It said for the claimant that it did, because it comes in at 102. Reaching his decision, he's borne in mind his assessment of the merits of the claim at this early stage.
Yes. And,
So what is being said, he should have said, or what I've got now,
yes.
it's a very strong claim in ground 2, and had he reached that conclusion, that would have affected his the outcome on the balancing exercise.
But that's a challenge, my lady, to his assessment of the evidence and the strength of the material that he saw before him. He had to conduct the exercise on the basis of that which he saw before him. He concluded that although it was a serious issue, it wasn't a strong case. He then went on properly to consider the balancing exercise in that context.
The criticism that's being made, we don't need to spend too long on it, the criticism that's being made is that he said, oh, but I'm going to bear in mind there could be further evidence down the line, so I can't make a firmer assessment. And what is said, I'm just asking you whether that
Yes.
he was wrong in his approach, because it said that he should have ignored the possibility of any evidence, any more evidence coming out down the line when assessing the merits on ground 2 for this, at this stage, for these purposes. I'm just asking you whether you accept that criticism or not.
My lady, no, looking at 102,
No, it's in the 70 section.
yes, but I was looking, sorry, at how he
The
resolved
criticism
the
is at paragraph 73. It
Yes.
says that's all wrong, you shouldn't defer.
Well, my lady, he had to defer
Or
because,
71, forgive me, yeah,
sorry,
no.
he had to defer. And in a sense, it cut both ways. Because he said it's likely order interferes with rights of claimant and many other supporters, etc. Didn't consider that Article 14 added much in that regard. That had been contested before him on our part, because we respectfully submitted that if the organisation is concerned in terrorism and the policy the exercise of discretion has led on policy grounds to a decision to impose an order prescribing the organisation, then the Article 10 and 11 rights are going to be very difficult to sustain in that context. He wasn't prepared to go that far, and all that the judge is doing is observing correctly that this is an interim relief application, it's pre-permission, he can only look at the material that he's got in front of him, he can only test the material put on in front of him by the Secretary of State on the basis of the grounds of challenge that are before him. And he conducted a very careful analysis of each of the grounds, only found this one to have reflecting a serious question to be tried, and then went on to consider it fully under the balance of convenience. And I read their last sentence of paragraph 102, reached this decision, I borne in mind my assessment of the merits of the claim at this early stage. It's just acknowledging the reality of the position, which is that we're pre-commission. He hasn't even actually had a summary ground of resistance, I don't think, yet from us. There's a Section 6 process that will follow, and then Section 8, and then a permission hearing in 2 weeks' time. All of that was properly open to him, in my respectful submission.
Sorry.
Is there anything else I can...
Yes, I think, is that all you want to say on ground 4? Can you summarise your response to the second, the far broader arguments put against you? What's the summary of your position on ground 4 then?
That there was no error by the judge in concluding that there was a serious question to be tried, while at the same time acknowledging that he couldn't, on the material in front of him, say that it had strong prospects of success.
That's one bit of ground 4.
Yes.
Covered that. What about, as it were, the second broader limb? If you look at the second bullet point of ground 4.
Yes.
This is the bigger point.
Yes.
And what do
sorry.
you say? What do you say in response to that?
And that the judge properly analysed each of the harms that were identified by the claimant, the applicant now, paragraphs 96 through to 101. That included consideration, for example, at paragraph 100, of the implication, the gravity of the imposition of the prescription order, implications directly for the organisation. Those protesting legitimately under the banner of the organisation may be deterred from continuing to protest. So that's the climate of fear, for fear of incurring criminal liability. For example, it might be perceived as expressing support for the organisation or on its behalf. The broad criminal prohibitions and the very long sentences potentially cast a long shadow of a legitimate speech. Exactly the complaint that's being relied on here. It's an inherent consequence of the regime, and with respect, that must be right. That's the part of the purpose of the operation of the scheme. Similarly, paragraph 99, that deals in terms with the implications and the risk that those who may unwittingly commit one of the strict liability offences. All of this was very clearly before the lower court and addressed by the judge.
What about the issue that it's not fair to penalise the whole organisation because some of the people in that organisation or that loose network might have done things that have crossed the threshold of being concerned in terrorism?
Well, my lord, the making of the order for prescription has no impact on anterior conduct. So nobody gets swept up in it by reference to things that they have done already. It's only in the event that from the point of prescription onwards
They can't do it.
that they then commit an offence, yes. Which brings us back to the ground one, because you're told in terms, this organisation is now prescribed. If you then decide to defy that, you have my submissions on whether that can ever really properly be in the balance, and you have the judge's view that it would be wrong to accord significant weight to that, but we did accord some weight.
Any questions? No, thank you very much indeed, Mr Watson. Anybody behind you brave enough to stand up at 9 o'clock on a Friday evening? All right. In reply, Mr Hussain.
My lady, thank you very much. I'll be very quick. 4 short points. One, we're well aware that this is an appeal against an interlocutory decision. The grounds we advance aren't simply that the judge was incorrect or even plainly incorrect, but they amount to errors of law. Secondly, on serious issue to be tried, the judge in fact found that grounds 4 to 8, he couldn't gauge the strength of C paragraph 91, where he summarises his conclusions on serious issue to be tried. The third point is that, and this is really important, with regard to ground 1, my learned friend Mr Watson provides no answer whatsoever to our submission that the judge, in a very important paragraph, paragraph 98, simply failed to posit the correct counterfactual. And that led to his paying insufficient weight to matters concerning a really quite dramatic interference with fundamental rights.
But you do have the heading, Mr Hussain.
Sorry?
You do have the heading, the harm that will ensue if interim relief is refused and the claim later succeeds.
Yes, but then when he says, lost the judgment. Yes, we have the heading, but if you look at the reasoning itself at 98, it doesn't square with that heading, because he says if individuals choose to continue to express their support or do any of the things set out, they will incur criminal liability. It's for them to decide whether to do so. That's the intended effect of the order. But what he doesn't factor in is that may be completely lawful, and he had to, and that is the basis on which he had to approach that, if indeed he was positing the correct hypothesis of the claim later succeeding. And Malone Brent's submissions are interesting because, as they were below, his submissions, I respectfully submit, beg the question. He says this is an interim argument. It's a peculiar argument that somebody's saying they have the right to defy the law. Well, it's not just any defiance, it's civil disobedience, direct action on matters of great public importance in circumstances where the contention is that the law is unlawful. And that is very much in the tradition of our common law. So it may have been that the judge was led into error, but it is very telling, we say, that my learned friend simply repeats the submission he made below, as he said, and simply just doesn't acknowledge that in that paragraph, the correct hypothesis isn't posited. Ground 2, my last point, is that even on the wrong hypothesis, the judge's hypothesis, we say, ground 2 speaks to the point that there are certain activities which are intrinsically protected by Articles 10 and 11. And they attracted very significant weight. If you say, I support Palestine Action, that is protected speech we respectfully submit. And you have my submission that attracts a 14-year sentence.
Thank you. Thank you very much. Yes.
My lady, very briefly, just to correct it, an error of impression that I think has been created. The appellant's case is that the court improperly held that the Article 10 and 11 rights of all persons capable of being associated with Palestine Action were of reduced weight in light of the serious acts of property damage caused by others. That was an error of law. This is not just about those who are deliberately or who will choose deliberately to engage in unlawful conduct in the future. It is about people who are engaging in what would otherwise be entirely lawful conduct, which will now be, through the prescription regime, be rendered not only criminal, but terrorist. It is not just about people who will deliberately thwart the law. It is about people whose speech will be chilled because of how broadly the law is drawn and the lack of clarity concerning its effect. And it is concerned with people who will try to keep themselves to the right side of the law, but will fail because of the broadness of the way that the prescription regime will apply for the first time ever to a broad network of protesters. It's worth noting that even Mr Justice Chamberlain asked the question as to whether lawyers instructed for the claimant would be able to represent her tomorrow after the order came into effect. And this was put to the defendant in his response that it wasn't for him to give legal advice. But how can an order come into effect when a judge is asking even that basic question and it is unclear on the face of it whether it would have that impact? The truth is that the prescription of Palestine Action, the first ever prescription of a protest group, has been improperly considered. The impacts of the prescription have not been properly considered and not properly assessed. It's capable of criminalising thousands of people who would not deliberately try to thwart the law, but will nevertheless risk falling foul of it with significant consequence and significant harm to them, even in the short term.
Thank you. Thank you very much. Just give me a moment, please. Well, thank you all very much indeed. You must all be exhausted. We obviously have to go away and make a decision now. We will have a decision for you before midnight. We will come in and announce either our decision orally without reasons and reasons to follow, or we will deliver an oral judgment, fully reasoned. We, when I say fully reasoned, in context, we will aim to come back at 10:05. Please do feel free to leave the building. I should take this opportunity to thank the court staff who have behaved quite exceptionally, both in terms of security, making arrangements for this evening. It's very, very late at the end of a very long week, and I'm extremely grateful to all of them. I'm sure the parties are as well. I think you'll be able to leave the building and come back in. Counsel only, parties, solicitors, obviously, but don't leave the building and find you're locked out. That would be unfortunate. But as I say, at the moment, our ambition is to come back in around 10:05 and deliver either a decision with reasons or a decision without reasons.
My lady, we're very grateful and obviously associate ourselves, both Mr Watson and I, with all the efforts of the court staff and security.
You've got water in the building, have you? Do you need anything? Are you all right apart from that?
Very much, Robbie.
You sure?
Yes, thank you.
All right. Thank you very much indeed. Thank you, boss.